Okay, so let's go ahead and get it started. Thanks again for all of you that have jumped on. I'm sure we'll have more people joining us shortly. So just a little bit about me for those of you that are don't know me. I'm a husband and father of three amazing children, as well as our fur baby. We have a German Shepherd who's about 3 years old. And I'm very grateful about being in this industry. Real estate and real estate investing has really offered me the opportunity to be a husband, to be a father, to be able to spend time with them and value quality time with family. And that's something, those of you that know me know that that's something huge for me, is to be part of my family, to be an example for my kids, as well as it has offered me the ability to be involved in the community. So, myself, my team, and my family are very involved in the community in many different ways. We support local events. I'm a proud Rotarian, so I'm very involved in the local community and doing whatever I can in different capacities to help out and be a better citizen. I'm also a volunteer youth soccer coach, and I've been doing that for about 6, 7 years now, and I love it. I love what it allows me to do for the community, and it allows me to be with my kids. So with that, with the love and passion of community, that really inspired me to do what we have here, is to put together this community of professionals, like-minded individuals, people that have something in common, which is business, real estate, something that ties us together, or real estate investing, to create this community of awesome people that we can come together and be a resource to one another, right? So the way we can benefit from this is to get to know each other and to know what type of services that we do offer, that we can help each other out. And again, to be a resource to one another this way. If no someone here today does not have what you need, like I said, I'm sure we have somebody in the community that can offer that. So I would love to be that resource to you, to connect you, to help you achieve your goals. So professionally, I'm a real estate broker. I run a team of agents out of the Compass in the Pasadena and La Cañada area. Our niche is working with investors nationwide in different capacities. So either we help them out like as consultants, finding and negotiating deals, partnership opportunities, or on a mentorship level. I'm also a very active investor, both in California and out of state. I do fix and flips, and I focus on the BRRRR strategy. So if you'd like to know more about that, I'd love to connect with you outside of this, and we can definitely talk about that. And my passion is helping new and inspiring investors get into the space of real estate investing and creating a personalized strategic plan that can help them, make money and achieve success, and more so wealth, and achieve a tremendous success. Something that I'm looking for, and if any of you, have that, is deals, right? I'm always looking for deals for either myself or my investment firm or other investors that I'm working with. So if you're an agent, you're a wholesaler, or you know of anybody that has a property that could be an opportunity that is off market, please reach out to me. I'd love to connect with you about that. Okay. So that's a little bit about me. Again, if anybody wants to share about themselves, just please raise your hand. And with that said, I want to welcome, Angela. Angela is a hardworking professional, is a community leader, is someone that I call a really good friend. She's a great asset in the space that she's in, and she's a fellow Rotarian as well. So Angela, welcome to the webinar, and thanks for taking the time to be here today.
Thank you so much, Alex, for inviting me to present, and thank you everyone for being here today to learn about estate planning. I'm going to share my PowerPoint. So a little bit about myself. I have two kids, two girls, 9 and 7, married for 15 years, and we have 3 fur babies, Coco, Mikey, and Lily. Um, And like Alex mentioned, I'm a Rotarian. I've been with Glendale Rotary for 6 years. It's my second family. I absolutely love being part of it. And I think being part of Rotary and meeting the people that I met and still meet every day just made me a better person and better professional. So let's jump into estate planning. Typically, when we talk about estate planning and when I speak to people, everybody mentions that they need a trust and a will. But estate planning is it's a package, and it includes all the documents that you see on the screen, and sometimes more. For example, if you have more than one LLC, more than one corporation, you have multiple properties, the list will get longer and longer. So when we are saying estate plan, we are talking about protecting your family and your assets after you pass away, and also protecting you and your family and your assets while you're alive, but you're incapacitated. And we want to protect your children if, God forbid, something happens to parents. We don't want the court to decide what happens to the kids. So all the documents that you see, these all documents have to be part of your estate plan. The main ones we usually discuss are the living trust, the pour over will, financial power of attorney, medical directive, and these are the ones I will go into in detail. Now, living trust, why is this such an important document in every state and especially in California? We all know about it, we talk about it, but there are many, many reasons why this document is crucial, especially if you have assets or property, real property in California. So the current law says that. So in California, if you own anything over $184,000, $184,500 at the time of your passing, your assets will go through probate. Now, if your assets are worth 1 million and the court fees associated with that are 46,000, this is a set fee. This includes attorney's fees that are set by law, by code, and then administrative fees and court fees, which means that you cannot negotiate with the attorney, or the attorney cannot charge you what they want. They are entitled to charge whatever the code says. So this is the minimum amount that you are going, your family is going to spend to go through probate process. So the solution for probate process is the living trust. And what is it? This is a document. It's a contract, but it's basically contractual document, which is revocable and amendable. And it outlines what happens when you pass away. What happens to your assets? Who's getting your assets? How are they getting it? At what age are they getting it? What other restrictions are there that you're putting in your trust? So you save money, of course, avoiding probate. In addition to that, it's a private document. In California, the trust is not recorded anywhere. So the only people who know what is inside the trust is you and the people you share it with. Versus if it's a will is recorded and it becomes public. So California decided that we don't want to record the trust. It has to be a private document. It also helps you to maintain your family harmony. Obviously, we know money changes people. Even siblings may fight, take each other to court, and spend a lot of money, never speak to each other again because of one property. So there's something magical about putting things in writing in black and white, which stops people from just being nasty to each other. In addition to that, we also, of course, put provisions in the trust that prevent people from taking each other to court. One of them being a no contest provision, which basically says if one of your beneficiaries takes the other one to court and they lose because they don't have proof, they're essentially disinherited from the trust. And control over your assets and distribution is something I mentioned. You can have control as to at what age your beneficiaries receive their assets. Do they receive it in lump sum, or they receive half at one age, half at another age? If they go to college, they can receive it sooner. If they don't go to college, later. So this is the beauty of a revocable trust, that as long as you have capacity, you have the power, you're in control, and you have the power to do whatever you want. You can change your mind about beneficiaries, distribution, you can buy property, sell property. Everything is in your control. Of course, as an attorney, I do not recommend that anybody gets a cookie cutter trust. And these are trusts that are created typically by LegalZoom or any we the people, or attorneys who don't really practice estate planning, but it's one of the things they do. And these are very, very basic trusts. When I review them, typically they're 8 to 10 pages. And if the property is properly transferred into the name of the trust, It will probably avoid probate. However, there are no other protections for the family at all. For example, when we draft a trust, we have all these provisions that are mentioned here. Structured distributions are the ones that I already mentioned. Kids receiving at certain ages, one person receiving more than the other, etc. If your beneficiary has creditor claims, creditors are coming after your beneficiary, the trustee has the power to withdraw distribution until that claim is resolved. Divorce is similar. If your beneficiary is going through divorce, the trustee has the power to withdraw distribution until divorce is resolved so that it doesn't become part of the divorce settlement. If you have a special needs beneficiary, we have the option of creating a special needs trust inside your trust, or we also give the power to the trustee to create a special needs trust if it is necessary in the future. For example, if one of your beneficiaries becomes disabled later on after you pass away, the trustee can create a special needs trust for that beneficiary, hire a lawyer and create that trust. If your beneficiary has substance abuse problems, drugs, alcohol, gambling, anything like that, the trustee has the power to withdraw distribution until for at least a year for the beneficiary to be clean. So they have to be clean. And sometimes I even put provision that says the trustee has to decide where they go to be treated. So there's more control the trustee has more control. And then frozen genetic materials. In the recent years, many women freeze their eggs. And in case they pass away, they want to decide what happens to the eggs. And some say, I want that to go to my family, my sister, or some say we want to destroy it. But this is now part of our estate plan if it's part of your life. And no contest provision, of course, is what I already said. We are trying to prevent family members, siblings from fighting each other and just being mean to each other. So this provision prevents people from being mean only because they may give up everything that was coming to them if they lose in court. So very powerful provision. Another thing you can do in a revocable trust is charitable bequests. Basically, if you are part of a charitable organization or you like a charitable organization, a nonprofit organization, we can have a provision where it says, I'm giving a certain percentage of my assets to this nonprofit or this charity. And of course, because they're 501c3 organizations, it's not only a gift, but it's also a tax deductible investment. And we can do different things with the charities or nonprofits. We can have a percentage, which is the most popular. People say like 1% of my assets goes to, let's say, the Rotary Foundation. It can be a certain dollar amount. It can be the entire residue or remainder of your assets, which means everything you own goes to the nonprofit. You can leave your house to a nonprofit, and then the nonprofit decides what to do with that property. Of course, donate stocks, bonds, or you can name the organization's beneficiary of your life insurance or any other beneficiary account that you have. Another excellent thing that revocable trusts have, the way they deal with Medi-Cal. So until 2017, whatever Medi-Cal paid to the person, they had the absolute first right to collect after the person passed away. In 2017, SB 833 was passed, and it says basically that Medi-Cal can come only after your probatable estate, which means if your property is in a trust, Medi-Cal cannot come after it because it's not probatable anymore. It's not going to go through probate. So any person who is receiving Medi-Cal, they can have their assets transferred into a trust and Medi-Cal will not come and collect. This was a huge change and it helped a lot of people who were obviously very worried that they were getting Medi-Cal. They were, worried that nothing's going to be left for their families or children. And this law changed that, and it's still the law. And again, you can imagine how beneficial this can be for a lot of families. And of course, let's not forget our fur babies. We can have a provision in any trust that says what happens to your animals and pets upon your death, who receives them, um, if you want to leave money to the person who's going to take care of them. If you don't have a person, your trustee can find a suitable home. We can have that language, or we can have language that says if there's no suitable home, then my trustee shall find a no-kill organization to place my animals in. In addition to that, we can also create a pet trust. So this is not part of the living trust. It's a separate pet trust where all the assets, the remainder of all your assets, go to the pet. These trusts, believe it or not, are much more complicated. The reason being is that pets cannot defend themselves and speak for themselves. So we have pages and pages of instructions, and we have multiple layers of protection, trustees, caretakers, so it is a lot more complicated, but we do it. And like you saw, I have my own fur babies, so this is near and dear to my heart. So those are the things we can do in your living trust. So living trust covers a lot more than just avoiding probate. The second document that we should have, any estate plan has to have, is a pour-over will. The pour-over will is not a regular will. This is a will that protects your trust in case something was accidentally left out. For example, let's say you have a trust, you have property in a trust, you're buying another property. And for whatever reason, let's say it's a bidding war, and you want to rush and you don't buy the property under the name of your trust, but you buy it under your own name. And it's never transferred into your trust. So you have a trust with properties in it, and then you have this one property that's hanging outside, and that property is going to go through probate. So the pour-over will, it's an insurance policy. It catches the asset that was left outside and puts it back into your trust with your other assets. So your beneficiaries end up going through a minor proceeding in a court instead of full-blown probate, and they ask the judge to please pour this asset over into the trust because clearly the trustor had the intention to have this property in the trust. It was just a mistake. So this pour over will is crucial. We would never prepare any estate plan without this document. Oh, another thing, nomination of guardians. So this is a separate, it can be part of your will or separately. I usually create a separate document that's nomination of guardian. The reason I do it separately is so that if you have changes later on, we don't have to redo your entire estate plan, but we can change the guardianship document. And this is for instance where if something happens to both parents, who's going to get your children? Who's going to raise your children? Now, if there's no guardianship document, of course, the court will decide, and the court will do their best, but the court does not know your kids. And sometimes they even have to separate the kids. And then this is where both sides of the families really fight in court. It gets really ugly. Everybody kind of forgets that this is about the kids and it becomes a war zone. If you decide, then the court will follow your wishes. And I know it's the hardest decision for parents. It was the hardest decision for me personally, but I will help you through the process because I've did it for me and I've learned working with other clients that we can find a solution. There is things that we can give and take and come up with the best solution for the kids. Now, it's important that you do this as a parent because you know who has a good relationship with your kids. You want to find somebody who has a similar parenting style. Where are they located? Are they physically close to your kids? Are you okay if the kids are uprooted and moved, or would you prefer that your guardian moves into your house for at least a year, takes care of the children, and then they move? Do they have kids of their own? Culture, religion, these are all important things for parents. I've had clients who nominated their neighbor as a guardian, not family members, because they're close to neighbors, they trust their neighbors, their kids grow up together, and their own siblings are not married, don't have kids, and they just don't think it was a good fit. So everything that I discussed up to this point, all of that comes into play when the person passes away. Now, the following documents, the durable power of attorney medical directive, these are your incapacity documents. So what happens if you're alive but you're incapacitated? Who's going to take care of your affairs? Who's going to be able to speak to doctors and make sure that nobody ends up in court? So the financial power of attorney, again, it's a legal document that allows your agent that you nominate to step into your shoes and do everything that you could do. So they can pay your bills, they can continue operating a business, they can file your personal tax returns. Now, I know people ask me, well, why can't the trustee do this? But trustee usually takes care of the trust and the trust taxes. Your agent takes care of your personal taxes, because if you're alive, even if you're incapacitated, if taxes are due, they're due. Your agent can enter into legal contracts. For example, let's say your incapacity was caused by medical malpractice. Your agent can hire a lawyer on your behalf and can go to court and fight on your behalf. Paying bills is something that comes up a lot. I've had people signing checks for their parents with their parents' names, which is fraud, but they have to use the parents' money to take care of the parents. They don't have $8,000 a month, for example, and they don't know that they're committing fraud, but it is. And if the bank finds out, it's going to be a huge problem. But if they have power of attorney, then they can deal with banks, sign checks, sell the property if they have to, move the parents to a nursing home, for example. So it's again very powerful document, and I get more calls about these two documents than probably anything else. But I usually get the calls when it's too late, when there's no capacity already, and I can't do anything at that point. But internet forms, there are internet forms that you can download and fill out. For example, financial power attorney. But the financial institutions and banks don't like dealing with internet forms. They like it when it comes from a lawyer and it's notarized. They don't want to take all the responsibility if they do whatever based on an internet document. They want less liability. So I haven't had anybody that used the internet form and did not have any issues with financial institutions. And medical directive is a similar document. In California, you have to give verbal authorization to doctors and medical professionals so that they will speak to your family members. It doesn't matter who it is, parent, spouse, child. If you don't give verbal authorization, they have absolute right not to discuss your medical condition. So what this means is if somebody goes into a hospital already in a comatose state, for example, or they have surgery, they go into coma, and then they're transferred into another facility, the doctors have a right not to discuss anything, because there were cases where somebody was in a coma. The doctors talked to the family members, told them about all their conditions and their health, and then the person came out of the coma and sued the doctor because in this particular situation, his wife did not know he had cancer, terminal cancer, and the husband said, I never authorized you to tell her. There was a reason I didn't tell her. So this is real.
Wow.
And we had another situation where a 19-year-old was crossing the street in college and got hit by a car, was in a coma for a month. The parents gave very minimal information to the doctors gave very minimal information to the parents. Luckily, she came out of coma in a month and gave the parents the power to speak to the doctors. Now, this is the verbal authorization, and a lot of people say, well, I took my neighbor to the hospital ER and they talked to me in front of me. The reason is because your neighbor didn't tell you to step outside. If the neighbor is speaking to you, to the doctor in the same room, and that's already given authorization basically to the doctor that you can speak in front of this person. But if they ask you to step outside, the doctors will not communicate with you anymore. Now, in addition to this, we have the federal law, which is HIPAA. And, we're familiar with HIPAA authorization forms that we sign so doctors can share our information, medical history. With the medical directive, we also prepare a HIPAA authorization form, which allows your agents to get physical medical records, do anything that they need to do, basically not violating state law or federal law. So everything is taken care of. The medical directive also includes your other wishes, such as do you want to donate organs or no? If yes, for what purposes? Um, I do authorize autopsy. If your family members want to have autopsy performed, are you okay with that? What are your thoughts on independent living? End of life decisions, which is basically under what conditions you don't want to be kept alive on a machine. And we have options for that you can choose from. Do you want to be buried, cremated? Do you want to have a green burial? Do you want to leave all the decisions to your medical representative? Whatever it is, this document includes your wishes, these wishes as well. So it helps your agents, your family members, because these are very, very hard decisions to make. So if they have any guidance, it makes it a little bit easier for them. Now, for the incapacity documents, anybody over the age of 18 in California needs these documents because at 18, you're an adult. Now, the doctors actually started now not giving information to the parents from around age 16, which is not the law, but a lot of parents call us and say, they're not communicating with us. The doctor is saying if she tells me, then my child's not going to talk to her. So, but the legal age is 18, and I work with a lot of parents who ask me to draft a medical directive for their kids that are going to college, um, so that they have the medical agent power just in case something happens to the child. And this document is valid in all 50 states, but I always recommend that in addition to the medical directive, the parents speak to the college and ask what additional documents they require or what additional forms they require. Most 18-year-olds don't have money, so we don't prepare power of attorney, but some do have it. Some have businesses already at that point, so we also prepare the financial power of attorney. If you do not have these documents and something happens and there's no capacity anymore, the only option left is conservatorship, where you have to hire a lawyer, go to court, and try to convince the judge to give you power over somebody, which they don't like doing because of all the abuse, financial abuse, physical abuse cases that happen. So hard thing to convince a judge. And you're going to spend 3 to 4 times more than you would have spent on an entire estate plan. So everybody needs these documents. Um, and this is it for me as far as the presentation. I'm open to questions if anybody has any questions.
And here's a slide with Angela's contact information. Obviously, you can reach out to her directly as well.
Yes, you can email me, you can call me or text me if you have any questions. I'm happy to answer.
Awesome, awesome. Anybody has any questions? So I've been away from the chat just because I didn't want to mess up the presentation in any way. I think Daryl has a question. Go ahead, Daryl.
Yes, thank you, Angela. One quick question. You didn't mention the other type of trust as far as the irrevocable trust.
Yes.
Uh, and one question is, do you deal with a lot of people who have family members that are going through dementia or TBI or anything of that nature to where to avoid the guardianship, they get the power of attorney in order to transfer property and, be pays on Social Security or pensions?
So to the second question, yes, as long as the person has capacity to allow me to create the document, because the person is the client. So if they have capacity to say I'm giving immediate power of attorney to this person, then yes, I can create the document, I notarize, and they can have it. But if there's also already no capacity, especially if they're already diagnosed with dementia, then I cannot help them anymore. And if they're not diagnosed with dementia, but there are some signs of memory issues, then I talk to them, because a lot of people, they have memory issues, but they don't have dementia. It's just, I have memory issues sometimes. So I talk to them and I ask them questions, and based on their answers, I can say, yes, I'll work with them, or no, I'm not going to work with them unless the doctor gives a note and says that this person has capacity. For the irrevocable trust, I personally don't create irrevocable trust. Those are more complex and you need a tax advisor for those. But because the federal exemption limit is so high right now, it's 14 million per person. And only if you have assets above that, then there will be estate taxes associated with that. We don't create a lot of irrevocable trusts. The people who do complex trusts, they do create it, especially if there are businesses that are, very successful. I don't do it, but I have colleagues that I can refer if anybody needs an irrevocable trust.
Okay, thank you.
Mhm.
Great question, Daryl. And I've experienced throughout the years and with clients and personally many situations that, could have been handled differently or could have been smoother had the right documentation or trust or estate plan been in place. Currently, I have two clients, that I'm meeting with for a potential listing that, one of them, the father is um, in a medical facility, so they're in a situation where they need to act quickly, and they're probably going to be reaching out to you because I just connected with them last week and I'm meeting with them tomorrow in person. And then another client of mine, a past client, we became really good friends. The dad is getting older. I've helped him with multiple transactions, and then the son has to sell a property, and the dad's age and medical condition is getting very sensitive. So they were able to put together the trust, get everything set up. But sometimes people do that when it's a little too late. So that's why education and being aware of how important this is crucial to do it early on, because as Angela, as you mentioned, there are certain things that are going to change throughout time and throughout the years that you can always adjust, like pets or who do you want to give this to, and any strict limitations. But it's important to get it done because otherwise you're at the mercy of probate and other people making decisions on your behalf. So it's important to have.
I'm sorry. Also, too, I find with being in the real estate industry, the liability and exposure that a lot of my clients that have multiple properties put themselves in by having stuff in their name and, not setting up that next step of life, God forbid. We think we're going to be invincible, but, like you said, you run into clients who are either in a nursing home or have a stroke, and there's no documentation for you to handle the transition of properties. So, I try to advise all my clients to meet with their estate planners to get things in order prior to the events.
Indeed.
Absolutely. And
Indeed.
especially with real estate investors, of course, we recommend that each property be in a separate LLC. That's for protection from lawsuits. So if something happens on that property, they can only come after that property, nothing else that you own. And then secondary protection is the trust. But a lot of people, like Daryl said, they buy 10 properties and they're all under their name, or they have 6 restaurants, they're all under their names. They have partners, they don't have buy-sell agreements.
Partnership agreements,
Yeah,
yes.
there's so much we can do, but unfortunately, the trust is, a lot of people think that the trust can cover everything. It's not true. So you have to go to different professionals for different things. But you're right, there's so many people I see, and I feel so bad, that work so hard all their lives and nothing is done, zero protection.
Yeah.
Um, we try to educate.
So this ties with, obviously on the topic of real estate investing, this ties with asset protection, liability, tax planning, all those, obviously the different professionals, they come together to create a plan that's going to be suitable for you, your family, your life, your business, etc. This way, one, whatever you leave behind goes to the right people that you want it to go to, but then during your life cycle is you're able to protect your assets, like, Angela said, and it provides privacy. So it's very cool. Now we have two questions in the chat. One of them is, do pets or animals need a separate document to be taken care of? I think you touched on that.
No, they don't have to have a separate document. So it's part of your distribution part. It says all my pets will go to this person. Um, that's if you're giving your pets to a person. If you want to leave all your assets to pet, then yes, that will be a separate pet trust.
So that would be a trust. Okay.
Mhm.
And then we have another question from Judy. Can you give a ballpark range of cost for creating these documents? You know, maybe like a general trust. Is there like a starting point for cost that you can?
Yes. So for a married couple, it's 2,800, and for a single person, it's 2,500. The base, and when I say base, I mean it covers the 10 documents in the all
Okay.
the 10 documents and the notarization. But if you have additional properties, we charge extra because we pay the recorder's office. Also, one more thing I want to mention, if you have LLC corporation partnership, we create document called assignment of LLC interest or assignment of corporation interest, which says whatever assets I have in this LLC, whatever interest I have in this LLC, I'm transferring into my trust. So if you have one, we will include it in the price, but if you have more than one, we charge $150 for each additional one. But the base is, we are in the middle market base, so we can serve as many people as possible.
And it's so important. I know you touched on this, but I want to reiterate how important it is to go with the right source to do the trust. I mean, there's a lot of DIY options. You know, some people like to do that. But it's such an important document that, you know, at least have it revised or reviewed by a professional. Like Angela, this is your expertise. Just like in real estate, you know, there's many people that do a vast variety of real estate areas, types. Um, subject to or multifamily or single family. So you definitely get the better result when you're working with that specialist, right? And I've had
Exactly.
conversations with clients as well that they've had, trusts made that they're not even confident with that they want to review with somebody else. And you shouldn't have that feeling. You should have it done professionally. I mean, obviously, money does matter, but in the grand scheme of things, it saves you a lot by doing it right, whether it's less expensive or a little bit more expensive, but going with the right professional. So wanted to, emphasize that because I've seen things happen that are very unfortunate out there to
Also,
people.
attorneys have liability, and that's something you cannot ignore. When you're working with a paralegal or somebody who's not an attorney, there's no liability. So whatever documents they give, they give, but we have liability. And that's why we're always updated. That's why our software is updated. That's why we pay for everything to be correct. It's just, I think that's huge when you're working with a professional and the relationship you want to have. My clients are my clients for life. Even though I have a transactional relationship with them, every one of them has contact with me. Anything they need, any professional they need, because that's the relationship we build. It's not a one-time thing. We're not a mill. So I think that matters for a lot of people. And it is important to have somebody you can actually talk to. Like you said, I've met people who told me I have a trust and they give me a document that's folded like in half, a few pages. And then I've seen trusts that are not notarized because the attorney gave it to the client and said, go notarize it, and they didn't.
Hmm.
Or the property was never transferred into the trust. So if you're gonna do that, be careful. It has to be done properly.
That's a great point. And we still have some time for questions. Please keep on coming. Thank you guys for these questions. We have one more Nat dropped in there. It's do these documents need to be recorded?
So the trust, a will, none of them get recorded. The only thing that's recorded is your deed. And that's what protects you from going through probate. So the property deed that you have, it'll be transferred from your name to the name of the trust. And I prepare the deeds and I send it to be recorded. And that's how, when the title is under the trust, that's how it's protected from probate. Nothing else needs to be recorded.
And that gives you the privacy aspect, right? Because if you recorded your deed, your LLC, somebody could find out who you are afterwards. But on a trust, my understanding is they just know the trust name. They can't really know much further than that, right?
Are you talking about the recorder's title when you're looking?
Yeah, when
So
you
the
record.
title will have the trustee's name. So if you
Mm,
have a trust, it's going to be Alex Nahle as trustee of the, let's say, Nahle
got it.
Family Trust.
Got it.
The short one is Nahle Family Trust, but your name is with it. In LA, they may or may not accept. It's still a maybe. It's not clear because they don't like accepting documents without the trustee's name. But the problem with that is if you don't have a trustee name, it's easier to commit fraud. So we
Mm,
don't do it. It's liability on my end. So I
okay.
wouldn't do it if it makes
Very good.
sense.
Yeah,
Yeah.
yeah, yeah, for sure. So we have another question from Don. Can you talk about platforms like Trust and Will receiving 25 million in funding? This is obviously if you have the answer or anything to touch on that. And then what could this mean for consumers and for professionals in the field?
Well, this is similar to AI. People saying AI is going to draft wills and trusts, but I don't believe that people are anywhere near being ready for something like this. If most majority population does not have an estate plan, if they're not comfortable speaking to a person, I don't know how comfortable they're going to be just having these things drafted by platforms or AI. So far, my colleagues and I don't see it as a problem for us as professionals. And also, there's going to be a lot of changes because there are going to be a lot of mistakes that's going to happen, and those have to be corrected, and we're still going to have a lot of work correcting that. So
Yeah.
anytime something new comes up, there's more work for attorneys.
No, I could imagine. I mean, AI is disrupting. It could be, good in many ways, and it could be a challenge for certain industries, certain people. But just like you said, I don't think there's really anything that removes that person, the human touch from such situations, or even like realtors, real estate agents, and stuff like that. I personally don't. I get it that some people may not agree with me, and that's fine. I just think, humans, there's a specific place and role for
Yeah,
them.
also I can't imagine how do you discuss, like, I have parents discussing that their children have drug problems, crying, talking about the difficulties, talking about tragedies that happen. I just, it's a human thing that you have to kind of go through and talk through and comfort and find a way, a solution. So yeah, I think we're gonna still be doing these things ourselves.
And then one last question before we jump off is Jolana. Sorry if I mispronounced your name. She has a question about parents and their 16-year-olds, like privacy.
In my opinion, 16-year-olds should not have privacy.
Hey, yeah, I'm so pissed. I just recently found out about that. Is it kind of a matter of you going to the doctors with the kids and the kids can sign something, or does it get more complicated than that?
I don't have a legal answer to that because this is legally not an issue. So I think as a parent, you should just talk to your child and the doctor and see why, because I don't know, the doctor should tell the parents. I don't think 16-year-olds should have any, privacy issues with. But legally, there's nothing we can do. There's no legal document that I can say, here, go sign and have your parents talk to the doctor. That's only when they're 18 years old because the child signs, the child is my client, and they give the authority to the parent, but at 18. So I would say talk to the doctor and try to figure it out with them.
Okay, thanks.
Sure.
Great question. And I hope you guys can see the screen. I put up Angela's information. This way you can reach her email and her phone number. And I lied. There's one more question. Judy's asking, does she have to be a resident of California to use your services? Do you cover other states? What can you share about that?
So I'm licensed only in California. If you live somewhere else, you have property in California, I can create your trust. But if you live somewhere else, you have properties in another state, I would recommend that you see somebody in that state. It makes more sense. Yeah.
Perfect. All right. Well, thank you all for joining us on this webinar. I hope you found tremendous value. We hope to see you on the next one. The next time we'll be in at the Laurel Tavern. in person. So if you are in the LA area, please join us. It's going to be on March 25th, 6:30 p.m., Laurel Tavern. It's a great venue. We connect, we hang out, we have a drink or a meal and just get to know each other. And then the next webinar will be on March 27th. That's a Thursday at 3 p.m. Again, Daria will be speaking about investing out of internationally in Spain. This is something that she's actively doing right now. So that's going to be very interesting. We hope to see you there. And thank you again for joining us.
Thank you, everyone. Thank
Thank
you, Alex.
you.
Thank you.